I would like to now go ahead and call Alan Murakami from the Native Hawaiian Legal Corporation. If you give him a hand. We're going to squeeze him into our schedule.
I know. This is the biggest challenge, talking to somebody when they're going to eat lunch in 15 minutes. So, yes, Tom has said a lot about a lot of the work we probably do and overlap with. So I don't want to repeat that. But I do want to stress a couple things that I think are really important, not only to this community and the people in it, especially decision makers who probably don't appreciate aspects of the law that are in fact helpful to not only your interests but to Hawaiian interests. And I don't know your name. The speaker earlier talked about the base for the laws in Hawaii being the Hawaiian laws. And it is literally true. Under what's known as HRS 1-1, even with the overthrow, successive governments have always adopted the major land and resource laws of the past, including the Hawaiian Kingdom, in other words. And so that really does serve as a base that a lot of people don't appreciate, because it's only if they pass specific legislation that overrides those laws that regulate customary and traditional uses, for example, such as trails, such as the use of water, all the laws that the kingdom had still apply. Many in the private sector especially, and unfortunately attorneys in the private sector don't understand this. They come in thinking, oh, we're just another state just like Massachusetts used to be, which adopted the English common law, which is incorporated in Hawaii's law as well, but it is always subservient to the traditional laws of the Hawaiian Kingdom. And so if you understand that, you can understand some real powerful applications of what those principles mean in the modern context, because we have continued to adopt a lot of those principles regardless of all the changes that occurred, including the overthrow. And a lot of the work of the Native Hawaiian Legal Corporation is to try to incorporate those laws in the work and the litigation that we do. I wanted to say that while I'm very proud of the record that the corporation has achieved over the past 40 years, and it will be 40 years on October 4th when we're going to celebrate our anniversary. What we've realized, at least what I realized and emphasized in our latest strategic planning session, is that we win a lot of battles without winning the war. And, you know, I've been in battles. I made 30 years with the corporation last year, and I can recite you cases where we've won battles along the way but not achieved the ultimate end that the community groups or individuals we are representing really wanted. Not in all cases. Clearly, I think a vast majority of them, especially the individual cases, we achieved a certain result that is the end result. But some of the real tension-grabbing, headline-grabbing issues, some of them are involving trails, some involving, a lot of them involving water and the Hawaiian Homes Commission Act, actually. We have won battles along the way, but not achieved the ultimate end. It's the old story in Indian country about how they fight for water and they get water rights on paper, but they don't get water on the ground. Okay. And somebody made an allusion to water earlier, Ted maybe, about how these laws apply, and in fact they do apply. We're trying to apply them in the context of East Maui, for example, with a big struggle against the sole remaining sugar plantation. And all the laws, you know, you can look at the statute, which is new law, and look at the old principles that are incorporated in the current law from the Hawaiian Kingdom, and they all favor the Hawaiian taro farmers and gatherers there. We have a constitutional amendment that preserves those rights and requires the state to protect them. And yet, both the Water Commission, which regulates water resources, and the Board of Land and Natural Resources, which is actually the lessor of 33,000 acres of crown lands in East Maui. These are crown lands. These are the original lands that the king reserved for himself as private property that became part of the government lands today under the laws that were special. And not only is these waters being used by a plantation that has deprived these native communities of, you know, the essence of life, basically, it's coming from crown lands, 33,000 acres of it, and they're paying about 0.23 cents, point, okay, less than a penny per 1,000 gallons. I think if you ask any farmer, you know, what they pay for any irrigation water, I don't think they pay for any less than 35 cents. Some that are on the county system pay way more, because that's domestic water. But in the ag systems, I understand that the water, and I believe it's up to 70 cents now, is the minimum price you pay for irrigation water. That being said, back to trails. The same principles do apply in a lot of contexts. And what I wanted to emphasize is that not only is it based on these old Hawaiian principles, tried and true, that apply in a real-world context, because on a long-term basis, that's what makes sense. You know, it doesn't make sense, frankly, in the long term to move water from East Maui, 25, 30 miles, to Central Maui, where there's a desert, and try to keep that going. While you're depriving streams of habitats, irrigation water for taro growing in those very communities that are trying to sustain themselves for the long term. It just doesn't make sense. Similarly with trails, I think it's important to recognize the concept of being able to move amongst all the different ahupua'a along the coastline and to preserve that unique heritage. We've said it numerous times in our Constitution and in the laws that Tom has cited. But again, like with water, it seems like either because of lack of resources or a desire not to have resources, and certainly the lack of political will, the laws that are in place, which are largely favorable to Hawaiians and Hawaiian communities, do not get implemented or enforced. And I think you guys are well aware of that. So Tom is absolutely right. That we can go to court and fight for these rights. We'll prove ownership. We'll prove the right to get something. And then because of lack of resources or lack of will, or a combination of both, you don't have the actual thing on the ground, whether it's water or a trail or whatever other resource that the law specifically protects for the future generations. We saw this in a trail case in 2000, back in Kona, where I don't know if you guys have heard of the Hokulia case, but we took that case on largely in part of protection of iwi kupuna. But there was an issue, there were 4 major issues in the case, and one involved the alaloa on the Big Island. And in that situation, we had a water-worn or pohaku that were like cobblestones lining a stretch of trail at least a mile long to a mile and a half long. I mean, it's intact on the ground. You could see it, and when you looked at it, you could have said, oh my God, this is what Hawaiians in the 14th century, which is what one of the state archaeologists confirmed, looked at, because it was probably built in that century. Clearly making it a part of the ceded lands inventory and ceded lands property and in the trust. And in order to get its permits, the developer there conceded that this was historic property and needed to be recognized as such. Once he got his permits, without any permission from the Board of Land and Natural Resources, which is the only entity that could give it authority or permission, it took the position that it was their property. And that was really important because the 16th plan, the fairway for the 16th hole on the golf course, in the original configuration, looked like this. It rose in the middle, with a tee on one side and the hole on the other. And the planners, the Jack Nicklases who designed that course, looked and said, yeah, I can't even see where the ball's going to land. So without asking any permission, what they did is they went in, they dug up all those pohaku, dug it up. And you know, to Hawaiians, that was really sacrilegious, because we had testimony in place that basically said that it was generally the custom to have pule for the laying of all the stones in that alaloa, because they considered it's going to be there forever. And so what they did is they removed the stones, supposedly marked them so they knew exactly, and mapped them so they knew exactly, supposedly, where they were in place. And then they graded the fairway down. So now you could see the hole from the tee. And when we sued, we brought the evidence before Judge Ibarra, who frankly is one of the best judges in the state. And he saw that this is a local boy from Kona, and who had, as a boy, apparently gone down to the coast and fished along that shoreline. So he had some appreciation for this. And he forced them to put it back, restore it, and put the stones back the way it was. And I think that goes to show that, even in today's world, a modern judge recognizing ancient Hawaiian principles and law that have not been changed, and recognizing, together with that, a trust principle, which is not Hawaiian law, but it's founded on basic common law principles in Hawaii that have been adopted to complement the Hawaiian laws, can serve as a basis for protecting these important and unique resources. And so, that was a major accomplishment for us that did get finished. So I'm glad to report that it's possible to do that kind of work today, even with the laws that we have at Inani, even in the face of the overthrow, because we have laws that we definitely can implement and enforce, as long as we can get the judges to agree that should be enforced. We have other struggles that I can go on. We can have another day or two talking about them, where we have not been able to do that and achieve the final end. But some of these results, like the Haleakalaka Trail, are pretty good examples of stuff that works, and it shouldn't be broken. So anything that tries to threaten that, including the amendment to the Ancient Highways Act, which was passed before the overthrow, by the way, and incorporated into the laws of today, should not be changed. And there's a good reason for why they exist. So the last thing I wanted to highlight to complement the things that Tom talked about was the year that we started the Hokulea case, they had a major Hawaii Supreme Court decision. Again, an example of how these laws can be used still today, hundreds of years after they were first adopted by the kingdom. And complemented with constitutional principles that have been enshrined in our state constitution, recognizing these principles, although many developers and their attorneys do not. And what the Supreme Court said in 2000, that was a pretty big year, because they also decided the Waihola case that adopted a lot of the common law public trust principles that we still use today. But there was a case on the Big Island again, at Kaupulehu, and what was at issue there was the Land Use Commission's decision to reclassify those lands for this Four Seasons resort. And what they did, the Land Use Commission did, is said, well, you can have this reclassification, and it's okay that the Land Use Commission did it. I mean, the Land Use Commission did it, that they had the power to do that. But what was not allowed was for the Land Use Commission to condition that approval upon the developer doing the archaeological and historic properties work to satisfy the law. And what the basic court said, you can't do that. What the law says is that you're supposed to do that first so that it informs your decision making about whether to do the reclassification that was sought. And they then built upon what is known as the Koanahiki case that had been decided 5 years earlier, where it basically affirmed the constitutional provision that says that the state has a policy to protect all those rights traditionally and customarily exercised for religious, subsistence, and cultural purposes. That's a powerful statement. Okay? It can be applied in a variety of contexts involving water, and trails, and historic properties, but it's in the Constitution, and frankly, not even the legislature can mess with it because it's in the Constitution. That's how important a principle it is. And what the court recognized is that, okay, we've said earlier 5 years ago that the state has a duty to protect traditional and customary practices. And we're going to go beyond that because it's not clear enough. Now, every public agency has a duty before it issues any permit or approval. Number one, to identify any potential traditional and customary practices that are dependent upon the resources that are at stake in the approval of any permits in that area. They have to identify that. If they have any indication that it exists, whether it be accessing a trail, using water for lo'i, or gathering the streams, whatever it may be, the agency has to identify that. They cannot just turn a blind eye to that. Okay? Second, they have to assess. They have the duty to assess. Not the people that are objecting to whatever permits might be at issue, but the agency has a duty to assess what the impact of that approval will be on those recognized practices and rights. Okay? Number two. Number three, and they have a duty to reasonably protect them. In other words, the traditions and practices that are identified and assessed. So that's a pretty powerful holding. And we continue to use that till today. And hopefully we'll continue to use that. And it's based on the constitutional provision I just recited to recognize traditional and customary rights of Hawaiians. So the legislature even can't mess with that. But that's on paper. And then we have reality. And that's why the knowledge of people of these principles is so important, because as I say to a lot of people I talk to, I don't make this shit up. You know, it's not my law, it's your law. And it's a law that should govern developers as well as landowners. And we're not trying to make them the enemy. We're just saying, look, we all agreed to abide by the Constitution. We agreed to play by the rules of the game. And the rules of the game basically recognize these principles. So what is wrong? Why doesn't it add up? Okay, it says that here, you've agreed to abide by these rules and laws. And yet we see these results before these agencies. And I'd like to think it's not deliberate. But when you see it over and over and over again, you kind of wonder, do they understand this thing? Do they understand what this means? And I think so where Tom, I think, and I really, really want to see this workshop go is, number one, you guys should understand these laws, okay? Number two, you should be a backstop to any litigation that occurs that could be there to try to protect and enforce those laws. Because I've been in litigation where you win something, like Tom did, but bill went up, the AG for the state who got pulled into the plaintiff's side because they were under lawsuit. I mean, told me after the lawsuit, hey, we haven't disregarded the possibility of doing an exchange. So after all of that, all of these resources going in to prove their case, that they're the manager and steward of these lands officially, they're still talking about an exchange. And they have no concept about what historic property value there might be in that. It's just like, well, you know, so many acres here and for so many acres there, and that's the exchange. So that's where you guys come in, because it becomes a political issue at that point. They try to change laws. They try to, you know, manipulate the BLNR. BLNR members are there. I don't think half of them, I don't think 3/4 of them understand this, what I just told you in the last 5 minutes. And yet these are very serious duties that they have that cannot be ignored. And frankly, at some point, Tom, we should think about whether or not these guys should be held personally liable for understanding clear law. Because every state agency and every county agency head or official, as it should be, is immune from personal liability for being sued for damages. But that definition means that if you know what the law is, and that's up to you guys to keep telling them that, and they still do something against that law, as a trustee, they can be held personally liable. Okay, and I think, frankly, that's where you start getting people to pay attention. And that's where I am now after seeing years and years of this. Basically, officials acting oblivious. I don't know if it's deliberate, but in a way I fault the Attorney General's office for not briefing people, because I've seen that they do not advise their members of boards and commissions of what their solemn duties are. And yet these guys, remember this, they take an oath, each of these guys that have been appointed, they take an oath of office to defend and support the Constitution of the state of Hawaii. That's virtually the language in the Constitution of the state of Hawaii, that they will defend and support it. So you got to remind them about these things. And the more people say this, the more it becomes apparent that they should have known. I think the stronger the case becomes that, hey, you better take your duties a bit more seriously and to basically be swayed by prevailing opinion. Because frankly, the majority opinion in a lot of cases is irrelevant. Okay, you got to look to what the law says and what should guide public officials and their official conduct. So that does not mean, however, that we make all of these guys devils. As Tom has indicated, I think there are some dedicated people out there trying to do the good job, like our previous speaker, hopefully. And it it really behooves us to try to be their best friends, because it helps the brave ones in these bureaucracies who want to step forward and do their work. It helps them to know that they've got the public behind them. And I think that's what our challenge is, to be able to find that strategy, that mechanism, and that collaboration with government so that it does uphold the laws that are clearly there. And so I leave you with that, because at least the Native Hawaiian Legal Corporation now recognizes we have to be better than what we've been doing. We can win a few battles, but we want to win the war. And what that means is that the corporation has now officially decided that I'm the first one that designated as the Director of Community Empowerment. And the idea here is to complement our litigation and the issues we fight for by hopefully developing partnerships with communities and getting longer-term support for the issues that we litigate, and to build coalitions that will cement them rather than somebody trotting off to the legislature and trying to change the laws that were just enforced by a lawsuit. So I'm going to be in that position and welcome anybody interested that wants to invest their time in this kind of effort, because every major lawsuit, I think, needs a community behind it to really solidify it. And that's where we are strategically, and I hope you can join me. That being said, Tom, the only question I had for you at your last presentation was, we have to realize as a matter of trail issues, that there's a potential and real possible tension between what Native Hawaiians want for trail access to support their traditional uses of the resources around them, whether it be in the mountains or at the sea, or whatever they're doing that are traditionally based, and the public's unlimited access along those trails. And I say that because it's even more important today than ever before, because every time I drive to East Maui to go visit my clients, I drive past, what is that falls, Twin Falls? I don't know what the Hawaiian name is. And there's like 50 cars parked on the side of the road that were never there 10 years ago. And the only reason they're there is because they published the book Maui Revealed. But if that's a public access, I don't think Hawaiians would appreciate the fact that they're getting inundated by all of these tourists that want to overuse an area. And the traditional Hawaiian concept is you don't abuse a natural resource. You don't just come in and uninvited and take over a place. So there's still that debate that has to be, I think, internally resolved amongst even the people who want to preserve trails for potentially different reasons. And that is something that I think that is a challenge before all of us today, even in today. Is there a Kauai Reveal book too? I don't know if you felt it, but boy, I really saw it on Maui happening. And I'll leave you with that thought. I think the Hawaiian communities around are always supportive of being pono and following their traditions, so that hopefully people like in this room can come to a common understanding of what the future should hold for you. So thank you.
Thank you.